Muy buenos días a todos. ¿Me escuchan? ¿Funciona bien el audio?
Perfecto.
Sí, se
Se escucha.
se escucha perfecto.
Mi nombre es Oscar Aitken y quiero darles la bienvenida a esta clase de nuestro diplomado de la Universidad de los Andes. Tengo el gusto y el privilegio de presentarles el día de hoy a don Bruce Reynolds, quien es uno de los abogados y árbitros más destacados a nivel mundial en el área de derecho de la construcción. Bruce es co-managing partner de la firma canadiense especializada en derecho de construcción Singleton Reynolds. Actualmente es presidente de la International Academy of Construction Lawyers, de la cual también es miembro fundador. Fue co-chair del International Construction Projects Committee de la IVA. Fue past governor de la American College of Construction Lawyers. Fue founding governor del American College of Construction Lawyers. Es fellow del Charter Institute of Arbitrators. Bruce es también autor de varios textos legales de legislación canadiense, incluyendo el Construction Builders and Mechanic Liens in Canada, A Guide to Canadian Construction Insurance Law, Scott and Reynolds on Surety Bonds, así como innumerables papers y publicaciones legales en nuestro rubro del derecho a la construcción. Don Bruce ha sido reconocido reiteradamente como un prominente abogado de construcción y árbitro en numerosas publicaciones. Quiero destacar solo algunas que son probablemente las más conocidas para ustedes. Chambers Global, destacado en construcción, Banda 1, Legal 500, Hall of Fame, in Canadian Construction, Who is Who Legal, Global Construction Lawyer of the Year, 2 veces, Best Lawyer, Construction Lawyer of the Year, Award of Excellence, Charter Institute of Arbitrators. Y bueno, la verdad es que podría estar mucho rato hablándole de los pergaminos, las credenciales de Bruce, pero no me quiero llevar, digamos, mucho tiempo. Quizás solo contarles que en lo personal conozco a Bruce desde hace 12 o 15 años y he estado con él en decenas de conferencias, seminarios, paneles, y nunca deja de sorprenderme su capacidad de explicar con claridad, de explicar en fácil los temas más complicados, los temas más espinudos, con su sencillez y simpatía que lo caracterizan. Así entonces, Don Bruce, on behalf of the Chilean Society of Construction Law, la Universidad de los Andes, and myself, thank you for taking the time to be with us today, and the floor is yours.
Thank you very much, Don Oscar. Are you able to hear me clearly?
Very well.
Thank you very much. I'd like to start out by thanking you and Juan Valdez for inviting me to speak today. And having said that, I've prepared a short slide deck, and so I'm going to bring the slide deck up through share screen. Are you able to see the slides clearly?
Yes, Bruce, no problem.
Yes, you can.
Very good. Having been invited to speak to the group today, I asked if I could make a presentation on a subject that's become of greater and greater interest to me the more my practice moves through the decades of my involvement in the dispute resolution process as it applies to construction projects. And what I had conceived of as a topic was what I've characterized as intelligent dispute resolution design for construction projects. Having received the approval from Oscar and Juan Valdez to speak to this topic, which in my experience, keeping in mind I focus my practice on the dispute resolution side of the industry, seems to come up in relation to every project. I realized that it was possible to create a new acronym. So I've come up with the acronym IDRD, which you'll see sprinkled through the slide deck. So whether this new acronym exists only for the purpose of this presentation, or whether it has an afterlife, will be interesting to see. But I hope you find the topic to be of interest, because to the extent, as I was saying a moment ago, to the extent that your careers take you into the construction space, the resolution of disputes is really fundamental to the success, I would suggest, of almost every construction project. Now, of course, I'm a Canadian lawyer, and the bulk of my practice is focused within Canada. And so I thought it might be helpful to provide you with a bit of context in relation to the angle from which I approach the subject of intelligent dispute resolution design. So just a couple of points in relation to my angle of approach, which emerges, as I was saying, from the Canadian context. So Canada, as you may be aware, is a bijural jurisdiction. Canada, as a country, is a federation. We have a federal government. We also have 10 provinces and 3 territories. One of our provinces, the province of Quebec, is a civil law jurisdiction with a civil code, while the other 9 provinces and 3 territories are common law jurisdictions. Our Constitution Act of 1867, which was patriated from the UK in the mid-1980s by an act of the Parliament at Westminster, allocates jurisdiction as between our federal government and the governments of the provinces and territories by subject matter. Very importantly, for the purposes of construction law, the law of contract is allocated by our Constitution to the provinces and the territories as a matter of constitutional law. Therefore, the principal laws that govern construction contracts in Canada are rooted in Canadian common law, which is influenced by British common law, and to a much lesser extent by US law. Outside of Quebec, but within the province of Quebec, the civil law pertains, which, as you would know, is a mixture of the civil code, specific pieces of legislation passed by the government of Quebec in regards to particular subject matters, and judge-made law within the province of Quebec. Having said that, within the sphere of construction law, And I have had a number of matters in which I've advised where the projects were located within the province of Quebec. So I've had the opportunity to become familiar with the underlying principles. If you look at the underlying principles that apply within the area of construction law, you find a remarkable similarity of those underlying principles as between the common law portion of Canada and the civil law portion of Canada. Now, perhaps due to the bijural nature of our legal system, some areas of Canadian common law have been significantly influenced by the civil law. And our Supreme Court of Canada commented in a very important recent decision that this influence, this cross-fertilization, if I could use that term, between the civil and common law is a very positive aspect of the evolution of Canadian law, which is viewed by our Supreme Court of Canada as a living tree. So in Canada, although there are scholars who favor the concept of originalism, the predominant view as to the role of the Supreme Court of Canada in interpreting our law is that of the living tree of a law that's intended to evolve. And this creates a fertile basis for the civil law of Quebec to influence our common law and vice versa. And one example of this, or two examples of this, are the Canadian laws of unjust enrichment and the Canadian law of good faith. And this puts us in a position where Canada has diverged somewhat from other common law countries in regards to certain principles, including unjust enrichment and good faith. One of the more important decisions of the Supreme Court of Canada in the law of contracts of the last decade was a decision which found that there is an overarching principle of good faith that forms part of the Canadian law, Canadian common law of contracts. And this certainly distinguishes Canada, for example, from the UK. Two other brief comments about the Canadian context as it applies specifically to construction law. Number one, in the common law provinces of Canada and in the territories, each of the provinces and territories has construction lien legislation, which Canada inherited from the United States many generations ago. And as I'm sure you're aware, the concept of the construction lien, which is, again, analogous to the right of legal hypothèque in the province of Quebec, gives a supplier of services or materials to a construction project the right to preserve a charge against the property of the owner to partially secure its ultimate payment for the supply of those services and materials. The owner's exposure to having to pay people with whom it does not have a direct contract, however, is limited. In the province of Ontario, where I practice, the owner's obligation to those folks is limited to 10% of the price of the prime contract or the head contract or general contract, as we refer to it typically in Canada. Secondly, starting about 5 years ago, Canada beginning in the province of Ontario, brought into effect a new system, which is a combination of prompt payment obligations supported by adjudication on the UK model. This began in Ontario about 5 years ago and is making its way across Canada through the common law provinces. So that's a relatively recent development. But the importance of these latter 2 points, which are quite specific to the construction context, is that when we think about dispute resolution in the real world of trying to resolve disputes on construction projects, at least in the common law provinces of Canada, these other dispute resolution processes need to be taken into account. I'm not going to, in my presentation today, get down into the weeds of construction lien legislation. I concluded that that would be far too granular, and it would probably take about 8 hours as opposed to 90 minutes. So what I'm going to focus on in my presentation is fundamentally a contractual approach to intelligent dispute resolution design. But as I said, I thought it would be somewhat helpful to give you a flavor in regards to my angle of approach as a Canadian construction law practitioner. So when we think about construction disputes and how to resolve them successfully, the problem breaks down, I would suggest, into 2 types of processes. And you'll see that this slide in its title refers to prospective referral. So when we think about resolving disputes, once a dispute has emerged on a construction project, there has to be a process designed to see that dispute resolved. So when I use the term prospective referral, what I mean is that when the parties enter into the construction contract in the first place, the construction contract prospectively regulates what will happen if and when, I guess I should say, when a dispute arises. By comparison, the second part of my presentation is going to be focused on retrospective referral. And when I use the term retrospective referral, what I mean is referral of a dispute to a process after the dispute arises. And as I'll discuss when I reach the part of the presentation that focuses on retrospective referral, there are more opportunities to craft a process that is specifically designed to accommodate the actual dispute that has arisen, because you'll appreciate that at the moment you enter into the contract, you don't know what the configuration of the ultimate dispute may be. So you're trying to forward project based on past experience to say, here's a process that we're going to apply later on to whatever dispute may arise on this project. Sometimes that's a problem in and of itself, because by the time a major dispute arises and you compare the contractual provisions that are intended to allow for its processing, they're not well aligned. And I'll give you some examples of that. Having said that, I'm not suggesting that a contract shouldn't attempt to regulate future disputes, but I will suggest once we arrive at a part of my presentation that focuses on retrospective referral, that if you do end up in a situation of misalignment, the parties should be open to renegotiating the dispute process once they understand the actual configuration of a major dispute. So as I'm sure you're familiar with, any construction contract will, I suppose I have seen some construction contracts that actually don't contain a dispute resolution mechanism, but they're certainly few and far between. Almost every construction contract will contain a dispute resolution provision, and it'll apply on its face to any and all disputes that arise during the performance of the construction project. It's very common from the Canadian perspective, and I would suggest generally from the international perspective, for dispute resolution provisions of the prospective variety to provide for stepped dispute resolution. In addition to stepped dispute resolution, which typically provides for negotiation between the parties first, sometimes for mandatory mediation, but ultimately either arbitration or litigation, you will also find more sophisticated dispute resolution provisions that provide for dispute resolution boards or dispute review boards or dispute adjudication boards. So I'm not aware the extent to which your program may have delved into the subject of dispute review boards or dispute adjudication boards, but I'm going to touch lightly on those two particular subjects because they both present significant opportunities for successful dispute resolution if they're properly crafted and properly managed. Broadly speaking, though, when a major dispute actually emerges on a project, you're almost invariably faced with what I've characterized as the Goldilocks problem. So the Goldilocks problem is, or arises at the moment when you're faced with a large dispute, and you go back and you look at the dispute resolution provision, and you start thinking about how the dispute resolution provision applies to the actual dispute. And my experience is that the project finance experts who negotiate the contracts at the front end of a project that are not usually dispute resolution experts, more corporate and commercial folks, will have either taken an approach to the drafting of the dispute resolution provision, which is very granular. And so the dispute resolution provision will go on for page after page, and it will be very, very specific about the steps and requirements that are associated with, who gives what notices to set up a negotiation, and exactly what officials are responsible to participate in those negotiations, and how you might appoint a mediator if a mandatory mediation is called for. And if you get into arbitration, the clause that is hyper prescriptive will drill down to a very granular level in relation to the procedures that will be required to be applied within an arbitration. The problem from a very practical perspective, when you're faced with a highly prescriptive dispute resolution provision, is really quite simple. And that is that one party will have the money and the other party will be trying to get to the money. And the party that has the money will be gaming the clause to try and make it as difficult as possible for the pursuer to actually ever have any realistic prospect of getting to the money. So if you're trying to game the clause to give rise to delays and difficulties to place in the way of the pursuer, a clause that's too prescriptive is really a gift to the party who wants to delay the dispute resolution, because you can get into endless bickering about how a highly prescriptive provision is actually to be applied in the circumstances. The flip side of the Goldilocks problem is a provision that is very, very broad, very short, and doesn't really give the parties any direction at all about how to manage the dispute resolution process. In the absence of sufficient detail, there's also an opportunity for squabbling over how the general principles contained in a broad clause are to be applied in the real world. So I'm not suggesting that I have a silver bullet solution to this problem, but I am suggesting that the balanced provision that has just enough detail to suppress squabbling over what the clause means is to be highly valued as compared to a clause that's either hyper prescriptive or a clause that's insufficiently prescriptive. Of course, once you arrive at arbitration, then you have the arbitrator to call the balls and strikes. And that, if you have a strong arbitrator, can make things more efficient. But of course, until you arrive at that moment, if you're moving through a stepped dispute resolution process, the squabbling is facilitated by the fact that there's no policeman to tell people when they're taking positions that are unreasonable. So when we think about stepped dispute resolution provisions requiring negotiation, followed in some instances by mandatory mediation, followed by arbitration or litigation, as I was saying, it's typical of these types of provisions for a dispute, once it has emerged, to be required to be the subject of discussion initially at the project level, but followed by senior executive negotiation. And there are projects where the vast majority of disputes are successfully resolved through negotiation. And if that's possible, it's much to the benefit of the social ecosystem of the project. If the project participants can themselves sort out the disputes without bringing in external counsel, without bringing in a mediator without bringing in an arbitrator or having recourse to the courts, then that's a healthier project, in my experience, than one where dispute resolution has to become more and more and more formalized. Negotiation is not typically successful, however, and there can be many reasons for this. A couple of reasons that I've encountered are, number one, the folks at the project level are really psychologically invested in their version of the fact pattern that applies to the dispute. And the senior executives, whose job it is to try and negotiate these disputes to settlement, are briefed by the folks who have a very strong psychological and emotional investment in their version of reality. And so the senior executives arrive at the table briefed into the two opposing narratives, and it really makes it difficult to close the gap. One concept that is referenced on the next slide is what I refer to as the virtue of ignorance in that particular scenario, but I'll come to that in a moment. Having a project mediator appointed can be very, very positive. Some standard form construction projects in Canada require the parties not only to pass through a phase of mandatory mediation as part of the stepped dispute resolution process, but they require, the contracts I'm referring to also require the parties to appoint a project mediator within a fixed number of days following the execution of the contract. And the project mediator's job is to be on standby in the event that negotiations fail to resolve a dispute and either party invokes mediation. And if this happens, then a mid-project mediation occurs. And I'm going to have quite a bit to say about the subject of mid-project mediation, because I've been involved in a number of them over the last few years, and they've been quite successful. So I'm a bit of an advocate for mid-project mediation. The concept of a project mediator that's on standby is a good one, but it really should happen in the contract itself, as opposed to the parties committing to appoint a project mediator within a fixed period of time, because I would say that in 19 cases out of 20, the parties forget to appoint the project mediator when they should. Then when a large dispute arises, one party says, hey, we forgot to appoint the project mediator. We need to do that now. That would be the party who's pursuing the money. Then the party that actually has the money says, I'm not so sure. Maybe we don't need to do that, or I don't like your three candidates, but I don't have one to propose myself. So the appointment of the project mediator becomes an issue in and of itself. But the concept of having a mediator on standby, I would suggest is a good one. And then, of course, the final step in this type of dispute resolution provision provides for a final and binding mechanism. I have seen that mechanism be in the form of expert determination, although that's unusual in our jurisdiction. I think there can be a lot of virtue to expert determination. Expert determination can be particularly important and valuable once you get into considering the retrospective referral of disputes, because there are some disputes, as I'm sure you've all encountered, which are very, very specific and very technical. And if the parties are able to agree that a specific expert, shall we say, on the subject of concrete is respected by both parties, then, once you know that the problem's with the concrete, and there's a debate about the concrete at the technical level, if you can refer that dispute for expert determination, and parties are prepared to abide by the expert's decision, that can close the dispute out. And as an overarching principle, disputes that linger and plague the project are a problem in and of themselves, and there's a benefit and a virtue to getting closure and permitting the parties to move on. So expert determination doesn't typically, within our jurisdiction, form part of prospective referral. Every once in a while it will over specific subjects. It's much more likely to be accessed as a form of retrospective referral. And then, of course, we have a final and binding arbitration and recourse to the courts. Recourse to the courts can be more or less attractive to parties in a project that has an international component, depending on the perception of the strength of the rule of law within the jurisdiction where the project resides. The offshore parties, to put it somewhat differently, even within a jurisdiction where the rule of law is strong, let's use the United States of America as an example, can still be worried about getting hometowned, as they say, and may want to submit disputes to international arbitration just to avoid the risk of a local court taking an adverse view of an offshore party. So I referred a few moments ago to the concept of the virtue of ignorance. If it's true that senior executive negotiation can sometimes fail because the briefing of the senior executive is skewed, it's at least possible that the less the senior executive knows about the granularity of the dispute, the better it is in terms of the likelihood of the senior executive being able to negotiate the dispute to settlement. So that, I'm sure, sounds a bit counterintuitive, except I recently had a major dispute settle on the basis that a new senior executive came on stream within the owner organization and replaced someone who was heavily invested in winning and being right about their narrative in relation to the dispute. And the new executive said, I really don't want to get down into the granularity of all the facts in relation to this 5-year dispute. I just don't want to do it. I want to approach the problem from a pure business perspective and see if it can be resolved in that way. And he requested the contractor, a very large contractor, to send someone to negotiate with him who had no prior connection with the project, but had the authority to make a business deal. So these folks got together and they settled a very large dispute that was at that point about 5 years old and was the subject of a lot of intense feeling amongst the owner's team and the contractor's team who had been managing the dispute over that 5-year period. So these two gentlemen settled the case on principle. The challenge then became for the rest of the team to document an agreement that was best characterized by its gaps, if you will, than by its substance. However, because there was a very high level agreement on the money, the two teams were able to develop a formal settlement agreement that was ultimately executed and performed by the parties. So what this tells you, I think, is that in at least some circumstances, the perpetuation of a dispute is perhaps more psychological than substantive. And sometimes if you are able to bring in two new brooms, as they say, you might be able to break that type of gridlock. Part of that psychology is also driven by bonusing structures, particularly on the contractor side of the relationship. The project manager and the executives above project manager will frequently have personal bonus arrangements that will be influenced by the size of a dispute. So if you had a $10 million dispute and it could be settled for $8 million, then the project manager could get a $250,000 bonus. But if it's settled at $5 million, he or she might get a $50,000 bonus. That type of bonusing structure is almost designed to perpetuate disputes, and again, would speak in favor of what I've termed the virtue of ignorance. So again, when we think of the dispute resolution provisions that are entered into at the time of contract formation, the prospective referral mechanism, and from a Canadian perspective, that typical step dispute resolution process, as I was saying a moment ago, the prospect for mediation as a dispute resolution process has become more and more important, certainly in our jurisdiction. And I've already spoken to the role of the project mediator, but I'd like to focus on this slide and in a few subsequent slides on the benefits of mediation. If you can secure agreement to involving a highly respected subject matter expert, a person who has a deep understanding of the construction process, construction contracts, the modalities of dispute resolution, and put them with the parties in a mediative role. I mean, you know, if you don't mind my saying so, Oscar would be a perfect candidate. You know, someone who has built their career around understanding construction and the resolution of disputes that arise within this very specific context, and who is mutually respected. They can play a role in bringing a resolution into existence that would otherwise either never arise or only arise years later. And an experienced mediator understands that in mediation, apart from the agreement to show up and participate, and apart from the agreement that it's entirely without prejudice or privileged, confidential, can't be used in evidence against either party at a later date, there really are no rules. There are conventions in regards to how a mediation is structured, but depending on the creativity of the mediator, the process is infinitely flexible. In our jurisdiction, there are facilitative mediators who work with the parties to try and assist the parties to arrive at what one of our top mediators refers to as a mutually disagreeable resolution. And there are deliberative mediators. And now, deliberative mediators tend to be former judges who've retired and gone into the dispute resolution business. Deliberative mediators, in my experience, operate mainly by permitting the parties to state their cases to one another and then separating the parties. And then the deliberative mediator goes into one room and says, "You're going to lose. And so you need to cut your best deal here today and bring this dispute to an end, because if you persist, it's going to cost you a lot more money in terms of fighting the process. And in the end, you'll get a terrible result." And I'm telling you this as your mediator because I used to sit on the Ontario Court of Appeal. And if I were still on the Court of Appeal, I would find against you. My experience is that sophisticated parties don't react very well to deliberative mediation. The instant, and this is my view and my experience, the instant that one of the parties senses that the mediator has taken a side, the mediation is over because the party perceives the mediator to have defected and become part of the opposing narrative. So within our jurisdiction, facilitative mediation is really far more the predominant mode of mediation. And the success rates of this type of mediation are very, very high. In the order of 80%. There are a number of things that can cause a mediation to be unsuccessful, and one of them is a legal issue where the parties simply can't get over the gap of their disagreement, and where that legal issue is so pivotal that it will have a radical effect on the dollar value of a settlement. And we had a case like this a few years ago, and the legal issue only permitted of a yes or no answer. Either one party's interpretation was correct and the value of the claim was $1 million, or the other party's interpretation was correct and the value of the claim was $15 million. And so until the parties knew what the answer was to their disagreement about the interpretation of a particular contractual provision, they were unable to arrive at a settlement because the gap was just too great. And so there was a referral to final and binding arbitration of this single issue. And the arbitrator rendered a decision, and as soon as the decision was provided to the parties, they were able to settle. that's a little slice of retrospective referral within a prospectively established dispute resolution mechanism. But it was very helpful, and it was proposed by the mediator. So I think that's a good excuse for sliding it into this part of the presentation. Now, of course, and again, I'm not entirely sure the extent to which your program has taken you into the subject of arbitration. But as I'm sure you're all aware, and this is obviously in the nature of a high flyby, when we think about a dispute resolution provision that provides for final and binding arbitration, we have to distinguish between international arbitration and domestic arbitration. When we think about international arbitration, which is much more likely to apply to, let's say, a major infrastructure project where offshore participants are involved, we have to recall the extraordinary importance of the New York Convention, which, in respect of the subscribers, makes an international arbitration award enforceable in a very large number of jurisdictions around the world. And we need to think about the applicability of the model law to the extent that it has been adopted or not been adopted in a given jurisdiction. The model law has been broadly adopted across Canada. So Canada is a New York Convention jurisdiction, and Canada is a model law jurisdiction, which of course is very, very helpful in forming a well-regulated basis for international arbitration in Canada. And as well, each of the provinces has an International Arbitration Act, and the courts of Canada are very mindful of their obligation to support both international and domestic arbitrators, as I'm sure is the case in Chile. Other considerations, of course, that the drafters of a prospective referral mechanism have to take into account are: what is the governing law going to be? Where will the seat of the arbitration be? And will an arbitration clause provide for institutional arbitration, for example, ICC arbitration or AAA arbitration, or will it be ad hoc? And what will be the composition of the tribunal? Will it be a 3-person panel, or will it be a sole arbitrator? What will the procedural approach be if it's an ad hoc arbitration? Within an institutional context, there'll be, in effect, a subscription to the institutional procedural rules. In an ad hoc context, the contract can call out a set of rules, or that can be left to the arbitrator. Of course, once you're into arbitration, then you're in a truly formalistic adversarial mechanism, which is quite different from mediation. Now, I referred earlier to dispute review boards. I'm very much in favor of what I refer to as the classic DRB, which, as I'm sure you're aware, came into existence in relation to the Eisenhower tunnel project in the United States in the mid-20th century. The classic DRB is comprised not of lawyers or retired judges, but of preeminent engineers with a very high degree of respect paid to the members of the panel by both parties in terms of their technical expertise. A classic DRB is a standing panel of 3, and they are intimately familiar with the project, visit the project regularly, and are available not to render final and binding decisions, but to be available to discuss disputes with the parties and advise the parties based on their experience through recommendations as to how to avoid or resolve disputes. The track record of the success of this type of dispute resolution mechanism is very, very high, higher even than mediation. More recently, it's been suggested that there is a role for at least one lawyer on this type of panel. I have encountered cases where that principle has been borne out because the dispute contained not only very dense technical issues, but also rather nuanced contractual issues, which is an area where an experienced lawyer can make a contribution. Having said that, it's very important that if a lawyer is going to participate in a DRB, that they take a collaborative approach and not an adversarial or deliberative approach. The criticisms of standing DRBs really relate principally to their expense. If you're going to be bringing in 3 leading national experts or international experts and having them follow the project for a period of years, that's not an insignificant expense. So it's a big decision to be taken by the parties at the beginning of the project. The reference here to DRBs as dispute adjudication boards in disguise arises out of a specific case in our jurisdiction of Ontario, where a provision established a DRB comprised of 3 engineers, and it made them advisory participants up to a certain dollar threshold. And then after that threshold, they acquired final and binding decision-making authority. So the clause flipped them into, in effect, an arbitral panel. The problem was, in that particular case, the fundamental issue was a legal issue, and there were no legal experts on the panel, and unfortunately, they got the legal answer incorrect. So it's very important, I would suggest, if you're going to bring in 3 engineers to give the benefit of their engineering knowledge and experience, don't ask them to then function in effect as an arbitral panel. So DABs, strictly speaking, and we've got a number of projects now in our jurisdiction which are using dispute adjudication boards, are a contractual version of the UK model of statutory adjudication. A dispute adjudication board will render interim binding decisions, which should remain in effect and be acted upon by the parties, at least up until substantial performance of the project, or what in the UK would be referred to as practical completion. If you're going to have a DAB, then panel selection is very important. And I would suggest that you do want a senior lawyer on that panel, because that panel will be making decisions on legal issues. There's also a very interesting and very granular issue that's been the subject of a lot of writing internationally about how one would go about getting a domestic court to enforce the interim binding determination of a dispute adjudication board. And there are cases internationally going both ways as to the enforceability of these types of decisions. So that is my effort to cover the broad subject matter of prospective referral. As you'll see, the 1/3 of the deck that remains to be covered can be covered relatively quickly because there's a close interrelationship of the processes. It's just a question of applying an appropriate process to the dispute once the dispute has actually emerged on the project. So there's an expression that was utilized by an American a proponent of mediation. And what he was saying was that mediation, which, as I was saying a few moments ago, is almost infinitely flexible, is capable of fitting the forum to the fuss. So I'm suggesting that that phrase, which was originally describing the virtues of mediation, could also be applied to the virtues of retrospective referral of a dispute after it has arisen as a form of intelligent dispute resolution design. You immediately appreciate that once you are knowledgeable about the configuration of the actual major dispute that's facing the project, if you are then asking yourself the question, well, what is the best way to resolve this dispute? You're looking at a blank palette. I'm suggesting that you ignore the dispute resolution provisions of the contract unless you've concluded that they fit quite well. And so you're in a space of great flexibility. And that can include senior executive negotiation, mid-project mediation, including targeted arbitral referral, as I was saying a few moments ago. This type of targeted arbitration referral can be done fast track. That's what was done in the situation that I used as an example earlier. And it's a great logjam breaker. So I'd like to focus for a few moments on mid-project mediation. And I've done 3 of these in the last 2 years. So because this is a completely privileged framework of communication, a mediation in mid-project is a discussion taking place within a zone of safety. What you'll be faced with is a number of very important questions like, where is the project right now? And how long is it going to take now that the project has been driven into the ditch and we have to get it back out of the ditch and moving forward? How long realistically is it going to take us to get this finished? Because the original schedule will be inapplicable. And what's this going to cost? So in one of the mid-project mediations to which I just referred, by agreement, 2 working groups were created. And working group number 1 was a group of schedulers and a couple of senior executives from each party, and they were asked to go away and bring back the actual schedule for the completion of the project without turning their minds at all to why the project was seriously in delay, without attributing responsibility for anything that had happened. Look at the schedule forensically and tell us, how long is it going to take to get from where we are to the finish line, and what does that new schedule look like? Secondly, a cost working group was created, and the rebaseline schedule produced by the schedule working group was given to the cost working group, and the cost working group created an estimate, which was the cost of getting from where the project was at that time to the finish line. Once the product of those two working groups was available, there was then a formal mediation session, in-person mediation session convened, where the issue of liability was addressed and a monetary settlement was reached. That resulted in a change order to the contract, which rebaselined the schedule and rebaselined the contract price. Now, in this type of mediation, it is very important to establish a reliable cutoff date. And when I say cutoff date, I mean each subsystem of the project had to be properly understood, and great attention was taken in the settlement agreement to making clear what was released, because in rebaselining the project, it had to be made clear that no past issues could reemerge to further imperil the relationship between the parties once the settlement was put in place. That was the most difficult part of the negotiations that resulted in the minutes of settlement. So I referred earlier to senior executive negotiations within the prospective context and the benefit of fresh eyes and what I referred to as the virtue of ignorance. So if you're going to do this, you can either use the traditional negotiation model, which is not frequently successful. There's a variation on the traditional negotiation model that was utilized in a settlement negotiation between myself and a very prominent Canadian construction law expert named Duncan Glayhold, who's now the preeminent construction mediator in Canada. And there what we did was each party, in the face of a major claim, developed what would be their closing arguments to an arbitrator. So I developed my client's narrative. Mr. Glayhold develops his client's narrative. We then went and presented our thesis to opposing counsel as if it were a doctoral defense. Opposing counsel cross-examined us. Once this was done, we issued a joint memorandum analyzing the case to the two senior executives who were tasked with attempting to negotiate the settlement. We gave them separate confidential memos, and the two executives were successful in settling the case. Yet another model of senior executive negotiation, which I've seen used recently, is where, and I hadn't seen this done before, the settlement documents were negotiated first with a blank for the dollar sign, or for the dollar amount. So every one of the issues that had to form part of the settlement was addressed within the minutes of settlement. And then the senior executives whose task it was to try and come to an agreement on the dollars met and discussed this. And as I sit here, we're not quite sure whether they will succeed on agreeing to a dollar amount, but it's a different kind of approach to negotiation. There are very serious challenges, however, to trying to resolve disputes in mid-project. As I learned in the mediation to which I referred a few moments ago, where we rebaselined the project, it's really astonishingly complex, because you have to get your arms around virtually every aspect of the project. And what you learn is that it's a moving target, because as the lawyers are working on attempting to manage the mediation process, and once there's an agreement in principle, attempting to negotiate complex settlement documentation, in the real world, the project is continuing. And the parties are actually encountering new minor disputes. And so as you try and crystallize a mid-project resolution, the fact that in the real world things continue to evolve is really creates quite a challenging environment. And then, as I mentioned a few moments ago, you have to try and ring fence the past. You have to try and make sure that the disputes that are being settled don't re-emerge. And when you combine that requirement with complexity and the fact that the project is a moving target, it's quite a challenging hill to climb, but it is climbable, if that's a word. The benefits, if you can get a mid-project settlement of a major dispute, are that it extracts to a significant degree the hostility between the folks who are actually trying to build the project in the real world. You can also create new project management tools. In one of those settlements, we created an executive committee, a new dispute resolution mechanism that became available for the parties to try and avoid the kind of gridlock emerging yet again. And then finally, you can modify the contract. In one of the three settlements to which I refer, there were some particularly difficult contractual provisions that had really increased the level of hostility between the parties, and there was an agreement to modify those provisions, which proved quite helpful. When you're looking at a dispute after it has arisen, sometimes the only answer is full-scale arbitration. And arbitration has both advantages and disadvantages. It has the advantage of confidentiality. It has the advantage of being a bespoke process. So you can create an arbitration process retrospectively that could be fast track. It can be single arbitrator. You can agree on the applicability of certain procedural approaches that are particularly apt to the dispute as the dispute has presented itself. Disadvantages are, it really takes a lot of the energy that would otherwise go to building the project and deploys it into formal dispute resolution. It's quite expensive. The best arbitrators draw, as you anticipate, quite significant compensation, 2 teams of lawyers, all of that. And no matter what your best intentions are, it'll usually take longer, significantly longer than you think it should, but you end up with a final and binding outcome, which allows the parties to move on. And then sometimes it is necessary to take a dispute or a cluster of disputes into the formal court system. And again, there are advantages and disadvantages. Disadvantages, you could draw a judge in our jurisdiction expected to resolve an incredibly complex construction dispute who spent their entire career practicing family law, assisting folks with separations and divorces and who know nothing about construction or construction contracts or delay analysis or expert evidence or anything that really matters to the resolution of a complex construction dispute. In our system, post-COVID, you're also looking at very, very long wait times to actually get a trial. One big advantage is that whereas arbitrators are always concerned about not disadvantaging one party, giving rise to potential criticisms of having failed to meet the principles of natural justice. And so scheduling turns out in the arbitration context to frequently be a big negotiation that extends the schedule. The judges are able to say, without worrying about being criticized by anyone, you're going to be here on Monday morning and you're going to begin presenting your case. And I don't care what you have to say about that. That's just the way it's going to be. And that's actually a big advantage when it comes to the unquestioned authority of judges to make decisions to streamline the process and get it going and get it done. So in conclusion, as it relates to prospective referral, I'm advocating for a very thoughtful approach to the drafting of dispute resolution provisions. And when I say that, I mean attempting to arrive at that Goldilocks solution where you have not too much prescriptiveness, but enough direction to the parties that they're able to apply the clause with a minimum of bickering and squabbling about what it means. And I also speak very strongly in favor of the use of classic DRBs and in favor of project mediators and mid-project mediation being available within the dispute resolution provision of the contract. And when we think about retrospective referral, I'm advocating for being open, for both parties to be open to, in appropriate circumstances where the dispute or disputes that have emerged are not well aligned with the original contractual DRP, to be open to setting aside the contractual DRP and negotiating a bespoke retrospective referral. And within the context of that type of effort, being open to the utilization of expert determination, being open to retrospective mid-project mediation, including the use of targeted arbitration where there is a core legal issue that requires final and binding determination. If parties, notwithstanding having fallen into a dispute, are able to take an open-minded approach and work collaboratively on trying to set the table for a well-regulated outcome of their disputes, I would suggest that that's in the best interests of the project and in the best interests of both parties. So having said that, I'm mindful that we have about 10 minutes or so for questions. If you'd like to proceed in that direction, Oscar.
Thank you, Bruce. Tenemos unos minutos para preguntas y respuestas. No sé si alguien quisiera formular alguna. Yo voy a hacer una, entonces, para romper el hielo. Bruce, let me pose one. In connection with the very focused arbitration intervention for a particular core legal issue, do you encounter concerns? How do you approach them in connection with the res judicata effect of the arbitration award? Of course, the res judicata of the award of the arbitrator is focused to the matters being submitted to the tribunal. But that would be a concern on my part, whether I can truly and effectively limit the res judicata effect of that award to other issues in the contract.
Well, that's a great question, Oscar. I think you're absolutely right. The res judicata would engage in regard to the particular dispute in question as a necessary incident of the final and binding effect of that award. When we think about issue estoppel, that is to say, whether the proper interpretation of that provision could be re-engaged in regards to a subsequent dispute, the referral that I was using as an example specifically addressed issue estoppel and said that the decision of the arbitrator on the particular issue that was being referred would not be the subject of issue estoppel, and that any subsequent arbitration that called out the same provision would be run on the basis that the award of this arbitrator would not be admitted in evidence in any such subsequent arbitration. Now, having said that, the award, when issued, found in favor of the interpretive approach of the opposing party. I was counsel in that targeted arbitration. So the arbitrator found, and I was acting for the owner, and the arbitrator found in favor of the contractor. And even though we had nullified the potential future applicability of the interpretation of the provision in question, once we had the award, we treated it as if it was applicable in subsequent disputes. There was no appetite for rerunning the same argument, to put it slightly differently. But you're absolutely right to highlight the fact that you need to turn your mind to whether the award will be applicable in terms of issue estoppel for the balance of the project. So that's a great question.
Great, and goes without saying that arbitrator is basically discarded for any further proceedings. So that arbitrator will not hear anything else in connection with the parties of the contract, right?
That's exactly correct. It's a sole purpose appointment, and it's really intended, as I was saying, to be a very forensic intervention to break a log jam that's preventing the resolution of a particular dispute. It worked quite well. Our client was not unhappy with the result because it allowed for that dispute to be resolved and put to the side, and it reinvigorated a positive relationship with the contractor.
Thank you, Bruce. ¿Alguna pregunta en la audiencia? Don Erwin, por favor.
Yes. like prospective referral is exclusive to the contract. I mean, if many contracts consider to have arbitration as a dispute resolution mechanism. However, if it's considered to be, for example, a DAB or DRB, is it exclusive and the parties would not use a retrospective mechanism such as a mid-project negotiation in case they consider that that's the best way to resolve the eventual dispute that they could have during the project?
Well, it's a really good question. I think the best way to answer it is to think about the sequence involved. So the parties, step number one, enter into the contract. If the contract provides for a DRB, then as issues arise, and if you're using a DRB, the issues will frequently arrive before the DRB, before they are formally disputes within the technical meaning of the contract. And if the DRB is successful, as it should be 4 times out of 5, you either never have a dispute or the dispute is resolved through the assistance of the DRB. If the dispute continues, notwithstanding the efforts of the DRB, then in the contracts that we're most familiar with, you then move into the stepped dispute resolution process that I was referring to. In a stepped dispute resolution process that provides for mandatory mediation, you'll have a project mediator in place from the beginning of the project. The senior executives may be able to resolve it. If not, the mediator will endeavor to resolve it. If the mediator is unsuccessful, then you move into arbitration, or some contracts call for litigation. So that's the arc of the contractual mechanisms. And I think the sequence in which they would typically be applied. If the contract is well drawn and the dispute aligns well with that set of mechanisms, then you don't need to turn to retrospective dispute resolution design. However, in the real world of my practice, which is mostly focused on just resolving large construction disputes, you do fairly frequently encounter circumstances where something about the dispute makes it fit poorly within that pre-existing mechanism. And when that happens, what I'm suggesting is it's in the interest of the parties to sit down and have a privileged discussion about whether it's possible to create a bespoke dispute resolution process that is well aligned with the dispute. That won't be necessary all the time, but I do find that it's necessary, or perhaps I should say appropriate, more often than one might think, because theoretically, the contractual set of processes should permit of a rational outcome. However, sometimes it's just not possible, but folks are able to subscribe to a bespoke process that they can see is better fitted to likely achieving a resolution. So I hope that's a good answer to your question.
Mm-hmm. Yes, thank you.
¿Alguna otra pregunta? Si no, para ir cerrando. Bueno, vamos a dar por concluida la sesión. Bruce, thank you very much for your presentation today. It was very clear very thoughtful. And muchas gracias a todos los asistentes por acompañarnos a esta sesión hoy día. Y nada más que desearles un excelente resto del día. Thank you, Bruce. Gracias a todos.
Thank you very much, Oscar. It was an honor. Bye.
Bye bye.
Bye bye. Thank you.